Hi, this is Bill Siebers, elder law attorney, with an update for nursing homes and assisted living facilities regarding the latest developments in Illinois for Medicaid eligibility purposes. I'm providing this update on May 31, 2012. At the end of last week, Senate Bill 2840 passed both the Illinois Senate and the House and is on its way to the governor for signature. The bill spans about 424 pages and focuses on reforms in the Medicaid program. A portion of the Medicaid program, of course, deals with long-term care assistance and eligibility, which is something that's obviously important to all of you. And you need to be aware of even further developments that have taken place since the new rules were implemented in January. As you recall, January 1 is the effective date for a whole new series of rules that further restrict eligibility for long-term care purposes in Illinois. We went through some of those in a seminar that we provided to most of you out at John Wood, and we're going to be doing another seminar coming up to cover those rules that were actually put in place and the new provisions under Senate Bill 2840. In the meantime, though, I wanted to update you some of the key provisions that are altered in Senate Bill 2840 that were actually different as of January of 2012 include a reduction in the amount of funds the community spouse gets to keep from current levels, a reduction in the amount of income that the community spouse would get to retain, a reduction in the amount of the homestead exemption. Previously, there was no cap on the homestead exemption in Illinois. Now there's going to be a cap placed there. Further, under the current rules, someone could basically drag their feet for a period of time, apply for Medicaid, and then have retroactively approval 3 months prior to the application, up to 3 months prior. That was generally done where the family didn't get their act together and get all the information into the Medicaid office, which typically provided a kind of a 90-day cushion, if you will, for nursing homes and other care providers to be able to get reimbursed when the family was dragging their feet. Unfortunately, under the new rules, they've closed the window of opportunity there and require that the applicant be eligible, meeting the asset and income requirements for each of the 3 months prior to application. Without getting into all the gory details, at the end of the day, what you need to be focused on is making sure that those applicants that may need to apply for Medicaid are on the ball and you've got their families focused. Otherwise, your ability to get reimbursed for the care that you provided may be in jeopardy. And that's true across the board for purposes of the new rules that were implemented in January, and even more so with these rules under Senate Bill 2840. There are also further restrictions on eligibility for burial plans, prepaid burial plans, and some other provisions that I'll update you on at the seminar, but I wanted to provide you this snippet to make sure you were up to date and current. We'll be back in touch, and best wishes for a prosperous 2012.